You're on your way back from a meeting when your phone buzzes. The notification says you have a new email from your head of PR to you and your CEO. So of course you open it right away and you read the following. You've seen the headlines, you know the Me Too movement has garnered a lot of attention. How will you respond when it touches your business?
What can you do today to minimize the risk of public allegations, and what steps can you take to prepare should the day come? Given the increase in allegations of sexual harassment and the impact public allegations can have on any business, you do not want to be caught scrambling to respond.
In the next 30 minutes, we're going to walk you through the legal and strategy considerations you need to be thinking about now, including preventative measures. First, we're going to talk a bit about how Me Too has changed the way companies respond to claims of sexual harassment.
Second, we are going to share 4 key lessons that will help you and your company investigate and resolve allegations of sexual harassment, including an overview of some recent changes in the law that are intended to promote workplace diversity and deter harassment. The 4 lessons we are going to cover are: 1. Ensure that your procedure for handling complaints is robust and consistent, and proactively think through privilege concerns. 2. Develop a culture where harassment is not tolerated. 3. Stay on top of the latest changes in the law. 4. Correct without overcorrecting. Agreements providing for confidential arbitration were also commonplace. Since the Weinstein story broke and the rise of the Me Too movement, however, public allegations, whether in the news or simply on social media, have become the norm. As of June 2018, Time magazine reported that Me Too has publicly implicated over 400 high-profile executives and employees in the previous 18 months. In today's environment, quiet settlements are riskier, becoming harder to justify, and may not be in the best interests of your company. Given the Me Too movement's focus on calling public attention to sexual harassment by naming those accused of misconduct, there has been a public backlash against non-disclosure and arbitration agreements, which makes them far less useful than they once were and can even be damaging. In addition, courts have held that settlement agreements cannot prevent employees from communicating with the EEOC and participating in EEOC enforcement actions. Indeed, administrative enforcement is on the rise. The EEOC has reported that in fiscal year 2018, it filed 41 lawsuits involving sexual harassment, a 50% increase from the year prior. New charges filed with the EEOC alleging sexual harassment jumped by more than 12% over 2017 to more than 7,500, the first increase in at least 8 years. Should the EEOC decide to file its own lawsuit, the allegations will of course become public and any settlement must be publicly filed in court. While you will never be able to completely eliminate the risk of bad publicity, the focus of the Me Too movement is on ensuring that employers take allegations of sexual harassment seriously and that those who have engaged in misconduct are held accountable. The walkout of thousands of Google employees recently in response to reports that senior executives accused of sexual harassment were paid millions of dollars to quietly leave the company is just one of many examples. Ultimately, in the era of Me Too, the risk of backlash is greater where credible allegations of workplace harassment do not result in real consequences. At the same time, employers need to be careful not to overreact. So, how do you strike the right balance? And what legal considerations do you need to take into account?
As a starting point, let's review an employer's legal obligations with respect to harassment generally. These laws aren't new, they've been around for years. For many people, the first time they had ever heard of sexual harassment was in 1991, during the Clarence Thomas confirmation hearings, when Anita Hill accused Thomas, her supervisor at the EEOC, of sexual harassment. Although, as we know, Thomas was ultimately confirmed, Hill's testimony led to increased awareness of harassment in the workplace. After the hearings, the number of claims of sexual harassment filed with the EEOC more than doubled between 1991 and 1998, and women demanded better legal protection. Congress passed the Civil Rights Act of 1991, which added greater protections and remedies for victims of discrimination, including victims of sexual harassment. In 1998, the Supreme Court decided Burlington Industries versus Ellerth and Farragher versus City of Boca Raton. These cases and others state that employers have a duty to exercise reasonable care to prevent and correct promptly any sexually harassing behavior. In cases where no tangible employment action has been taken against the complainant, such as discharge, demotion, or reassignment, a defending employer may raise an affirmative defense to liability or damages subject to proof by a preponderance of the evidence. The defense comprises two necessary elements. One, that the employer exercised reasonable care to prevent and correct promptly any sexually harassing behavior, and two, that the plaintiff employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer or to avoid harm otherwise. This is commonly referred to as the Farragher-Ellerth defense. When it comes to establishing this defense, the Supreme Court has explained that while proof that an employer promulgated an anti-harassment policy with a complaint procedure is not necessary in every instance as a matter of law, whether a company had a stated policy suitable to the employment circumstances can be a part of the employer's defense that it acted reasonably. Moreover, a demonstration of an unreasonable failure to use any complaint procedure provided by the employer will normally suffice to satisfy the employer's burden under the second element of the defense. Where an employee did raise a complaint of sexual harassment, the reasonableness of the employer's response to such a complaint will be considered under the first element. In short, first and foremost, all employers need a robust complaint and investigation procedure for harassment complaints. This brings us to lesson number one. Ensure that your procedure for handling complaints is robust and consistent, and proactively think through privilege concerns. Your best defense to any civil suit or public allegation is that the company conducted a thorough investigation and responded appropriately based on the findings of that investigation. Therefore, you need to ensure that your company is clear and consistent in how harassment complaints will be handled. This requires you to establish a consistent process for handling complaints and communicate that process to employees. How will employees raise complaints? The key consideration should be accessibility. Keep in mind that raising complaints of sexual harassment can be extremely difficult. Some employees may not be comfortable going directly to HR or to a manager. Who will handle complaints once raised? How will these individuals be trained, and how much discretion will they have? On the one hand, it may be difficult to come up with a set procedure that anticipates every possible scenario. On the other hand, too much discretion can lead to inconsistent approaches and results. How will the results be documented? You need to be able to keep track of outcomes, whether in individual personnel files, separate employee relations software, or otherwise. How will you ensure consistency and accountability? Consistency and accountability will be easier to track if you maintain centralized documentation rather than in individual personnel files. Consider implementing an audit or review process to ensure that those handling complaints are acting fairly and consistently in terms of both the thoroughness of their investigations and their conclusions and the outcomes. Importantly, no matter how good your process is for handling internal complaints, for complaints made against individuals in senior leadership, an independent investigation by a third party may be warranted. Any company will have difficulty defending its internal investigation process when the person investigated holds a key leadership position.
Whether you involve in-house or outside counsel, you need to be aware of how reliance on the investigation or disclosure of its findings may affect your ability to claim the attorney-client privilege. Be aware that if you want to rely on your investigation and any remedial measures taken as part of a defense to a civil suit against the company, you will likely waive privilege. Courts have repeatedly held that employers raising a Farragher-Ellerth defense waive privilege over their investigations because an assessment of the reasonableness of that investigation and any remedial measures taken is necessary to determine whether the elements of the defense have been satisfied. That said, at least some courts have held that if non-attorneys conduct the investigation, an employer can maintain privilege over communications between those investigators and counsel. Separate and apart from any reliance on your investigation and litigation, disclosure of the investigation's findings and any recommendations prior to any civil suit may also waive privilege. You may be tempted to share an investigation report that clears a key executive of wrongdoing. You may even be inclined to share a report that faults the accused in the interest of transparency. Although underlying facts are not privileged, counsel's reliance on certain facts informing their opinion is. It can therefore be difficult to draw a clear line between privileged communications and work product and non-privileged factual information. As a general guideline, the more information you disclose, the more likely you will waive privilege over the entire investigation. In other words, you cannot use the investigation as both a shield and a sword. A good example of how courts assess privilege waiver in these contexts is the decision in Doe 1 versus Baylor University. A few years ago, numerous allegations of sexual assault surfaced against Baylor students. In response to the allegations, Baylor retained outside counsel to conduct an investigation. At the conclusion of the investigation, outside counsel released its findings of fact and recommendations. In litigation, the plaintiffs argued that Baylor had waived the attorney-client privilege largely due to this disclosure. In response, Baylor argued that the report only disclosed underlying facts and not privileged communications. The court rejected Baylor's argument. In summary, the court explained, the findings of fact reveal that all findings were the result of outside counsel's investigation. A detailed, thorough, and rigorous investigation based on unfettered access to personnel and data. Contrary to Baylor's assertion, this connection between outside counsel and the 13 pages of findings reveals what facts Baylor provided to outside counsel, not just the underlying facts themselves. In other words, the findings of fact are a publication of evidence of the communications. Although Baylor had not raised the investigation as a defense, the court concluded that it is enough that the university selectively disclosed confidential attorney-client communications publicly to warrant a finding that it waived the attorney-client privilege with respect to those communications as a whole. In addition, even if you do not disclose the results of the investigation publicly, you also need to consider the risks of internal dissemination of any report. In the face of a challenge to the privilege of attorney-client communications, courts typically examine whether the communications were disseminated beyond those who need to know the information. Ultimately, while in-house counsel or outside counsel should certainly be involved in any investigation of sexual harassment, you need to keep the following in mind. Limit internal disclosure of the investigation findings to only those with a need to know. If you are considering public disclosure of an investigation's findings and recommendations, be aware of the risks and be thoughtful about what you choose to disclose. And at the end of the day, you are safest not to assume that investigation materials and communications will remain privileged and to proceed accordingly when communicating internally about the allegations and the investigation.
That takes us to lesson number 2. Develop a culture where harassment is not tolerated. It is, of course, critical to develop a work culture where sexual harassment is not tolerated. This often requires more than implementing an anti-harassment policy and mandatory training. It requires attention to company culture more broadly. For example, a culture based on rigid hierarchy and the consolidation of power may facilitate conditions for harassment. Psychological studies have found that power is associated with a reduced tendency to comprehend how other people see, think, and feel, which can impede empathy, a flaw that likely lowers the social and moral barriers to harassment. In addition, the majority of the high-profile cases of sexual harassment involve situations where the harasser had a disproportionate ability to affect a subordinate's career. The cases of Hollywood moguls harassing up-and-coming talent are prime examples of this. In addition, there have been rampant allegations of sexual harassment against venture capitalists by female entrepreneurs seeking investors. These scenarios not only make it difficult for victims to speak up, but also make it difficult for bystanders as they too fear negative repercussions. While you will not be able to completely eliminate a hierarchical structure at your organization, you can consider ways in which power can be diffused. For example, the absence of clear and consistent policies on things like promotions and internal transfers can facilitate opportunities for harassment to the extent the policy vacuum allows individual managers to wield too much power and discretion. By contrast, policies that reduce the influence of immediate supervisors by, for example, requiring others to be involved in decisions around promotions and transfers, limit opportunities for employees to abuse their power. Another way to diffuse power is to adopt a 360-degree review process. This is a review process through which feedback from an employee's subordinates, colleagues, and supervisor, as well as a self-evaluation by the employee themselves, is gathered. In contrast to traditional reviews, which are done only by an employee's immediate supervisor, 360-degree reviews allow employees to be assessed from multiple perspectives. This eliminates scenarios in which a single individual has the power to decide whether an employee gets a good or a bad review, which at many companies can also affect compensation. In addition, fostering a culture of accountability generally will discourage would-be harassers from crossing the line while also encouraging the targets of harassment to speak up sooner rather than later. This requires consistent enforcement of company policies unrelated to harassment. When employees see their coworkers and leaders being held accountable in other contexts, they are more likely to be willing to believe they will be held accountable for sexual harassment. In some circumstances, you may want to implement new policies in order to provide guidance on behavior expectations. For example, companies are increasingly revisiting their policies with respect to alcohol consumption at work and work functions. The most common scenario we see of workplace harassment involves drinking. We've all heard the story of the office holiday party in which a coworker drank too much and crossed a line. While you don't need to eliminate alcohol entirely from all company functions, it is worthwhile thinking through the circumstances in which alcohol is provided and to set guidelines around expectations. Importantly, even if the event is not an event that is formally company-sponsored,
Importantly, attention to diversity, particularly in senior leadership, also plays a role. Me Too has already morphed into discussions about the absence of senior women from companies and gaps in average earnings between male and female employees. Research has continually shown that companies with more women in management have fewer allegations of sexual harassment. In response to these discussions, the California legislature this year passed an amendment to the California Corporations Code that requires publicly traded firms in the state to place at least The law requires boards with 5 or more members to add even more women by the end of 2021. Now, it is certainly questionable whether the law is constitutional, as it specifically creates a classification based on gender, and therefore raises questions of equal protection under both the U.S. Constitution and the California Constitution. After signing the bill into law, Governor Brown even recognized that the law would be challenged and may not withstand scrutiny. However, regardless of whether it is enforceable, the law is clearly designed to send a message that more needs to be done to promote gender equality at the highest levels of corporate America, and is reflective of the sense that companies need to be pushed to do more on this issue. Even before the law was passed, there has been mounting pressure on companies to review and release their diversity statistics, including statistics on women in leadership roles, promotion rates between men and women, and the company-wide gender pay gap. While conducting such an audit can be extremely helpful in terms of identifying areas of concern or in need of improvement, sharing the information is not without risk. Some companies have made the decision to be transparent despite underwhelming diversity statistics in order to convey that they recognize the issue, set a benchmark for where they are currently at, and publicly commit to improvements. While the initial disclosure of poor diversity statistics may invite criticism, disclosing the results of an initial audit can allow the company in later years to publicize its progress as measured against the results of its first audit. Any decision to publicly disclose diversity statistics should weigh the pros and cons for the particular organization. To the extent information is released, be sure to have a communication strategy in place to present the information and respond to employee questions and concerns. For example, be careful about how you describe the statistics and the results. You do not want to be accused of mischaracterizing the data, such as by focusing on statistics that are good for the company to the exclusion of statistics that are less favorable. You also need to be aware that once you disclose that you have looked at this data and have the data readily accessible, any current or former employee asserting a claim of discrimination will be aware of this data and will likely seek it in discovery. While these reviews may be done by counsel under cover of privilege, any disclosure of the results may limit your ability to rely on the privilege.
Next, lesson 3. Stay on top of the latest changes in the law. Be cognizant of the fact that the laws in this area are changing and stay on top of all of those developments. As of January 1, 2018, no deduction is allowed for any settlement or payment related to sexual harassment or sexual abuse if the settlement or payment is subject to a non-disclosure agreement. No deduction is allowed for attorney's fees related to a confidential sexual harassment settlement or payment. In addition, there have been a flurry of legislative changes at the state level. California passed a law effective January 1, 2019, that will void any settlement agreement that prevents the disclosure of factual information related to a claim filed in a civil action or a complaint filed in an administrative action regarding sexual assault or sexual harassment. In other words, settlement agreements cannot prevent plaintiffs from discussing their allegations and other factual information related to their claims. The law does, however, allow the parties to agree to keep the amount of the settlement confidential. Washington has passed a similar law, voiding non-disclosure agreements to the extent they would prohibit an individual from providing evidence in a civil action regarding past instances of sexual harassment or sexual assault by a party to the action. New York and Massachusetts now require employers to have written sexual harassment prevention policies, including a procedure for making internal complaints. A number of other states have passed similar laws directed at countering sexual harassment.
Another target for legislative reform is pre-dispute arbitration agreements. At least one bill has been drafted at the federal level that would make pre-dispute agreements that require arbitration of a sex discrimination dispute invalid and unenforceable. While the prospect of passing such legislation in the near term is slim, you should expect efforts to restrict pre-dispute arbitration agreements of sexual harassment claims to continue for years to come. Some companies have even preemptively revised their arbitration agreements to exclude claims of sexual harassment or sexual assault. These changes to mandatory arbitration policies signal a corporate culture in which the company understands that requiring arbitration of sexual harassment claims may dissuade victims from coming forward, and also signals a corporate culture that values accountability, even where the accountability comes from painful public disclosures. These types of legislative changes are likely to continue. It is therefore critical that you stay up to date on the legislative changes in any state where your company has employees. This gets us to lesson number 4, correct without overcorrecting. Acknowledge that our culture is changing, but resist the temptation to overreact. It is understandably unnerving for many to see the numbers of those toppled by accusations grow. The recent summary dismissals of high-powered executives and celebrities have triggered worries that any person might be accused and ruined by false allegations, or that their past behavior could come back to haunt them as a career wrecker. In response to this fear, a number of studies show that men are becoming more hesitant to interact with and mentor female colleagues. For example, respondents to a Source Media survey on attitudes towards sexual harassment in the workplace post-Me Too voiced concern that women would be excluded from work situations in order for men to protect themselves. One senior leader in the banking industry reported that several male colleagues had told her they were reconsidering mentoring women. A Pew Research Center survey asked respondents whether they thought that the recent focus on sexual harassment had made it harder for men to know how to interact with women in the workplace. 51% of all adults questioned said yes. As another example, Lean In partnered with SurveyMonkey to look into the possible negative effects of the Me Too movement for women's advancement. Nearly half of male managers they surveyed reported being uncomfortable participating in a common work activity with a woman, such as mentoring, working alone, or socializing together. Senior men were 3.5 times more likely to hesitate to have a work dinner with a junior-level woman than with a junior-level man, and 5 times more likely to hesitate to travel for work with a junior-level woman. Almost 30% of male managers are uncomfortable working alone with a woman, more than twice as many as before. While fear is understandable, permitting men to be so protective that they refuse to engage with women so that women are excluded from opportunities will only lead to other problems down the line. Allowing an environment to develop in which men fear establishing mentoring relationships with junior women will likely limit women's advancement opportunities and could lead to charges of discrimination by women who feel excluded. The reality is that men play a critical role in fighting harassment in the workplace. Rather than allowing this fear to persist, employers should provide guidance and resources for men to do so.
A fantastic way to do this is providing bystander training. As the New York Times recently described it, bystander training equips everyone in the workplace to stop harassment, instead of offering people 2 roles no one wants, harasser or victim. Bystander training should focus on providing employees with choices of what to do as a bystander, such as interrupting a situation in which a coworker is being harassed, talking to the harasser later to convey how they came across during the situation, talking to the victim later to acknowledge what occurred. Interestingly, studies have shown that the training will be more effective if men are involved in the training. For example, one study found a backlash against training when it was done by a woman, but not when it was done by a man. Even if you cannot have a man conduct the training, having a male senior executive speak to the importance of bystander intervention could have a similar effect. Regardless of who conducts the training, bystander training can provide a launching pad for discussions about respectful behaviors everyone agrees on. In addition to bystander training, communicating to all employees that investigations in response to any complaint will be fair and consistent reinforces the sense that all employees will be treated fairly and equally, whether they are reporting harassment or being accused of harassment.
So, turning back to our original email, how will you respond? Can you say that you have a policy and consistent process in place for making and investigating complaints? Can you easily search to see if any complaints have been made against your key executives? If so, do you also have access to the results of the investigations? If you cannot locate any specific complaints, how confident do you feel that your company has fostered a culture in which harassment will not be tolerated? Do certain managers wield disproportionate power? Are you aware of concerning comments in employee engagement surveys or otherwise? Are you up to speed on the latest laws of the relevant jurisdiction? Do you have a plan with respect to publicizing any report or investigation?
Ultimately, how you respond to this Me Too moment will require balancing multiple concerns, and we have only been able to touch on some of them in this training. As lawmakers respond to increasing allegations of sexual harassment and as the public mood shifts, Decision-making around investigating and resolving complaints and identifying appropriate preventative measures is sure to become more complicated. For example, from a preventative perspective, if you audit your diversity statistics and identify a disparity, either in hiring, promotions, or pay, what can you do about it? If you decide to focus on recruiting more women, how should you go about it without raising concerns of gender discrimination?
In addition, in what scenarios are you under an obligation to report allegations of sexual harassment to your board of directors? And once you do, what is the scope of the board's responsibility? A related concern is how to keep investigations confidential, particularly investigations of key executives while they are ongoing and before any conclusions have been reached. These are just some of the questions you may face as you navigate through this cultural shift. Thank you for watching.
For decades now, employers have had anti-harassment policies in place with regular training programs for managers and employees. With the emergence of the Me Too movement, however, we see now that many of those policies and training have been ineffective. The movement brought to light the degree to which these issues have been underreported in the past. But in the era of Me Too, the fact that victims fail to report harassment to their employer does not mean that they remain silent. Instead, they may circulate lists of colleagues to avoid, write explosive blogs, or go straight to social media with their stories. In times like these, organizations cannot afford to not know about harassment in their workplaces. It is too costly a risk to take. The average out-of-court settlement in a sexual harassment matter ranges from $75,000 to $125,000. And the cost to defend a sexual harassment claim through trial can reach upwards of $250,000. But more than dollars and cents are at risk. The failure to prevent or promptly respond to a Me Too crisis can also cause significant damage to an organization's brand and public interest. Today, we will walk through what organizations should consider to try to prevent a Me Too crisis and what steps to take to manage a crisis if one occurs. I'm going to start by giving you some background on the landscape of sexual harassment, reporting and response, both before and after the Me Too movement. Then we will discuss some new considerations organizations should make in light of Me Too. Finally, we will walk through the basics of crisis management and outline proactive steps that organizations can take to reduce the risk of a crisis in the workplace before it starts. It goes without saying that the Me Too movement has proved to be a watershed moment for how we view and treat sexual harassment in the workplace. In order to understand why the Me Too movement is a new paradigm for employers, it's worth spending a few minutes discussing the sexual harassment landscape before the movement. In the pre-Me Too era, employers could rely on legal or technical ways to fend off claims of sexual harassment. For example, an organization could assert that the victim failed to complain about conduct to allow the organization to conduct an investigation and remedy the situation, or two, that the conduct complained about was not, quote, severe and pervasive, close quote, or that the claim was asserted too late and barred by the statute of limitations. And when an incident of harassment was investigated and substantiated, an organization typically entered into a settlement agreement with the complainant that included a non-disclosure and confidentiality provision. Thereafter, the complainant was typically reassigned to a different role or department in the organization away from the alleged harasser. Or alternatively, the organization paid the complainant to leave the organization. When harassment was actually substantiated, high-level offenders typically received a warning or training. The end goal in responding to the harassment claims was to keep the claim and settlement secret. All of this has changed with the coming of the Me Too movement. I have been at the forefront of this movement, helping organizations in the midst of the headline news crisis. I develop management techniques to ease internal stresses, strategically communicate internally and externally, and execute a legal strategy, all with an eye towards giving the affected organization the best chance of reaching their immediate and long-term goals. Starting in October 2017, women in Hollywood began coming forward with allegations of sexual harassment and assault perpetrated by the prominent film producer Harvey Weinstein. This spawned the emergence of the hashtag #MeToo, which became the vehicle through which other women shared their own personal experiences with harassment. The hashtag instantly went viral throughout the nation and worldwide. The hashtag was posted more than 12 million times on Facebook by 4.7 million users in just the first 24 hours of going live. As more and more women revealed their own sexual harassment experiences, many prominent men, not just in the entertainment world, but virtually in every other organization and sector of society, became the subject of Me Too allegations. Within this broader cultural shift in perspective, we have seen material changes in the workplace. In the post-Me Too era, we now have a rapid increase in claimants coming forward with allegations of sexual harassment in the workplace. This is a drastic shift from the underreporting of complaints we saw in the past, which was banded together with inadequate reporting channels, distrust in those reporting channels, and fear of retaliation for reporting. The Me Too movement has provided a platform to bolster these complaints and compel more individuals to come forward. News and opinions about bad conduct amplify quickly because of the far reach of social media. Employers must also grapple with a new level of public accountability, increased internal and external scrutiny, and a greater risk for reputational and business harm. So while the legal standard for what is sexual harassment and the defenses to such claims have not changed, the enforcement standard has definitely shifted. With that in mind, boards of directors are very concerned about the damage that can be done to an organization's brand in the face of a Me Too crisis. In the legislative space, many lawmakers see Me Too as a call to action to implement new laws and other measures to protect the victims of sexual harassment and assault, while at the same time removing sexual harassment from a cloak of secrecy. For example, there are bills pending in the House and Senate that would exclude sexual harassment claims from mandatory arbitration. Several states and municipalities already have passed similar statutes or regulations. Also, the Tax Cuts and Jobs Act, signed into law by President Trump in late 2017, includes a provision meant to discourage organizations from offering hush money to silence victims of sexual harassment. Section 162Q of the Act, now dubbed the, quote, Weinstein tax, close quote, will force organizations to determine whether to include a non-disclosure provision in a settlement agreement or forego deducting sexual harassment-related settlement amounts as an ordinary business expense on future tax returns. What are organizations doing in response to these changes? So in light of the new actions and attitudes brought about by the Me Too movement, what are organizations doing differently? Many are taking a more comprehensive approach on how to make, quote, zero tolerance, close quote, for sexual harassment move from policy to practice and a permanent reality. Responding to Me Too in a meaningful way requires a holistic approach to addressing workplace harassment, discrimination, and retaliation, and incorporating that approach into a larger commitment to diversity and inclusion. Organizations can't fire their way out of this problem. And changing corporate culture requires an organization to do more than publicize, update, or change its policies, reporting mechanisms, and training. Instead, employers must re-examine their organizational toolkits for addressing the cultural issues underlying these workplace problems. To change corporate culture to one of compliance, organizations need to engage in a campaign that is multifaceted. Such a campaign requires, one, evaluating corporate policy to align it with the culture that the organization hopes to achieve. Although a clear, comprehensive sexual harassment policy is an essential component in preventing harassment, any policy's effectiveness is ultimately a function of the cultural norms that leaders foster in their organizations, as will be discussed more in my next point. Organizations should also reevaluate their reporting mechanisms to determine their effectiveness and consider implementing additional measures like a phone app for employees to make complaints. Enforcement and accountability of these policies at all levels of the organization are key. Second, the campaign requires setting the tone from the top. The Me Too movement has presented a unique opportunity for leadership to set the tone in rebooting corporate culture. The board of directors, the C-suite, and other top leaders have a highly influential role in shaping and defining the culture throughout an organization. Third, the campaign requires hiring and promoting to enrich the workplace with diverse talent. Leadership should encourage managers to interview a diverse bench of candidates for each open role at the organization. Fourth, organizations need to enhance training to explicitly convey what is expected and required of employees. The focus should be on comprehension of the policies instead of mere legal compliance. Employers should also consider incorporating other topics, such as workplace civility, implicit bias, and bystander intervention in their trainings. Fifth, in addition, organizations must keep a handle on significant power imbalances within an organization. What many sexual harassment scenarios have in common is that the harasser wields some power over the victim. And finally, employers must act quickly and appropriately. Failing to acknowledge and punish sexual harassment and misconduct can convey a very direct message to employees that the behavior is acceptable and that the reporting of such behavior will not end it. Instead, the message that an employer should be sending is that everyone is valued and respected, and there is demonstrated commitment to diversity, inclusion, respect, and safety. Going forward, be particularly sure to stay abreast of the law and the news in the Me Too context. Along these lines, we will highlight some new and emerging issues to keep on your radar. First, shareholder lawsuits. The Me Too movement could trigger a wave of investor actions. To illustrate, Wynn Resorts Board and former CEO were hit with a shareholder derivative suit after the stock fell 20% when sexual harassment allegations against the CEO went public in early 2018. The suit claimed that the organization and its board of directors breached their fiduciary duties by sweeping accounts of Wynn's misconduct under the rug for decades. It is plausible that similar claims of breach of fiduciary duty could surface in the aftermath of Me Too. Second, there may also be changes to insurance. Carriers offering EPL insurance are now demanding that organizations institute or update anti-harassment policies and procedures, and are also making sure that anti-harassment training actually takes place. Third, we also expect an uptick in gender pay inequity claims. Me Too has pushed forward the focus on gender pay gap. In a recent survey, 48% of organizations say they are reviewing their pay policies with an eye toward closing the gender pay gap. Lastly, look out for the EEOC's new sexual harassment guidance, which is currently awaiting approval from the Office of Management and Budget. This new guidance will supersede several previously issued EEOC documents on harassment from the 1990s.
A crisis can arise in many contexts: Me Too allegations, environmental incidents, product failures, certain kinds of government investigations, a governance challenge, and data breaches, just to name a few. These are all crisis moments for organizations. But what exactly is a crisis? A crisis can take a few forms. An emergency or catastrophic event that happens without warning, that is often public and sensitive in nature. The classic examples are an oil spill like Deepwater Horizon, or a data breach of sensitive consumer information. A crisis may also take the form of an evolving issue. In these situations, the government, the plaintiff, or the whistleblower identifies a potential issue that has some public or media appeal to it. These types of crises may start relatively narrow, but then expand into multiple dimensions. And then the third type of crisis is one that may be avoided through foresight or containment. Generally, these are the slowly evolving issues we just talked about, where steps can be taken to minimize the crisis. But regardless of the type, one thing that all crises have in common is they put pressure on the entirety of the organization and require rapid, coordinated action that addresses short-term problems without affecting long-term prospects for the organization. It likely comes as no surprise to you that a true crisis involves multiple dimensions. In some crises, like Deepwater Horizon, for example, an organization may experience all of these dimensions in play. But in other crises, you don't see them all, but you see many of them. Often, you'll start with a government investigation. If that becomes public, you then may see congressional hearings or the state attorney general coming into play. And this, and for other reasons, there needs to be careful coordination with the organization's accounting firms and insurers. Perhaps the most vexing aspects of a crisis concern external communications. Everyone wants fast answers. Shareholders, regulators, customers, the media, and employees, just to name a few. The pressure is even greater in this era of social media and 24-hour news. In many, if not most crises, the organization will be pressed for answers, including the cause of the crisis and whether any ongoing harm has ended. Often these questions and complicated answers are not available with 100% certainty at the beginning of a crisis. But 100% accuracy is crucial to credibility and critical over the long haul. Often this may mean that the organization can address what it's doing about addressing the crisis, but must stay away from matters that are still not fully known. and managing the flow of internal information with an eye towards discovery in the inevitable litigation is critical. These are all reasons why we recommend putting in place a crisis management plan that considers the different facets and dimensions of a crisis in advance. You want to plan and consider when there is time to do so, rather than in the vortex of the crisis. Now, while we may be unable to anticipate all crises that an organization may face in the future, what you can do is to put together a crisis management plan. And having that plan in place alleviates some of the stress on the organization's decision makers during those first few chaotic but crucial hours and days of a crisis. Now, as an initial matter, we would recommend designating one of your outside firms as your legal crisis manager. You should draft the crisis management plan in conjunction with that legal crisis manager. The crisis management plan, then, has at least 3 elements. First, anticipate possible crises that your organization could face in the future. Consider your industry and crises that your peers have faced. Look at trends in government investigations, whistleblower lawsuits, and class actions. Evaluate the security of consumer or other third-party data you hold. And then second, pre-plan. Outline immediate response steps. That's critical. Third, identify the key members of your core crisis management team and your communication team. Describe their roles and decide what authority they have. Doing this planning in advance will streamline decision-making in the heat of the crisis. You can then focus on substance, not process. In addition, you should provide authority to individuals on your crisis management team to, number 1, direct resources. 2, support any outside crisis managers like outside counsel and communications professionals. 3, control the organization's message to ensure a unified voice in a crisis. 4, communicate with government responders or investigators. And 5, make sure we know who's going to begin the difficult work of evidence collection and preservation. On this subject, evidence collection and preservation, it will be important to identify one person on your team who will be in charge of data collection and preservation and who has knowledge about IT structure and backup systems. This will be a big role. The person will be tasked with managing document review and retention and coordinating and preparing for personnel interviews. To get you started on who should be included on your crisis management team, you'll see next to me a list of potential key players on a crisis management team. You'll notice the list contemplates selecting roles for members of your organization from top to bottom. We recommend including on your crisis management team the CEO and relevant business unit leaders, general counsel, in-house counsel, and outside counsel as your crisis manager, someone in corporate communications, an outside communications consultant, someone from investor relations and government relations, the compliance director, someone from IT or record management, and someone from building or facility security. Your crisis management plan should have a section on communication strategy, and it may be helpful to identify an outside crisis communications team in advance. And as I noted, there is an inherent tension between the need to say something to your constituents without getting ahead of the facts and making a well-intentioned but erroneous statement. And on that, it's important to know that the Department of Justice has gone as far as threatening criminal action against organizations under the mail fraud and wire fraud statute for making statements following a relatively benign comment explaining the course of a crisis that later turned out to be incorrect. It is therefore critical to strike a balance between providing important information to the organization's constituents while also ensuring that any communications are unquestionably accurate. As you are considering when to communicate, how to communicate, and what to include in your communications, you must be cognizant of future litigation and the potential for discovery of internal communications. Consider that every press release may end up as a potential exhibit at a deposition or a trial. And on the substance of your communications, there are generally 4 different communications approaches, and your crisis management plan should lay out different scenarios and the applicability of the following responses. A first approach is full disclosure and immediate acceptance of responsibility. A good example of this communication and response approach is Johnson & Johnson's approach in 1982, after it learned that several people had died after taking cyanide-laced capsules of extra-strength Tylenol. The organization immediately admitted fault and recalled 31 million bottles of Tylenol and offered a free replacement of regular-strength Tylenol. The second communication approach is limited disclosure with limited and/or rolling acceptance of responsibility. An example of this approach is the Exxon Valdez oil spill, where Exxon's chairman did not comment on the oil spill for nearly a week, but ultimately apologized for the spill while not accepting responsibility. An example of this approach from the Me Too movement is Senator Al Franken, who resigned in the face of accusations of sexual harassment, but in doing so, neither apologized nor accepted responsibility. The third communication approach is denial, which may very well be the right answer in some circumstances, but could also look to the public as a cover-up. For example, when Martha Stewart was accused of insider trading, she denied all accusations and held fast to her claim of innocence. And then the fourth is to take responsibility for addressing the crisis, without accepting responsibility for its cause. In looking at these options, it's important to know there is no one-size-fits-all. And if accepting responsibility has limited repercussions or puts tight limits on liability, that may well be the right approach. On the other hand, there may be circumstances where statements accepting public responsibility carry with them serious civil or criminal ramifications. And in those cases, it may make sense to express commitments towards eliminating future harm without accepting responsibility. Your crisis management plan should cover your internal procedures for managing the creation, retention, and content of written communications. Assisting you in this process should be the outside law firm which you have designated as your crisis manager, and your crisis manager can then set guidelines for communications with third parties, like a communications firm or PR firm, and can assist you in structuring your relationships with these third parties in such a way as to enhance privilege protection. In this regard, one of the least appreciated risks in planning communication strategy is the inadvertent waiver of the attorney-client privilege and work product doctrines.
One of the best ways to stay ahead of Me Too crisis is to check the cultural climate. Now, more than ever, employees are evaluating their workplace culture, both in response to specific complaints and Me Too allegations, but also as a proactive and preventive measure. The goal in assessing the culture is to identify risk and develop concrete solutions that promote a positive, inclusive workplace, mitigate the possibility of litigation, and preserve the organization's brand and image. Culture assessments adapt to the particular organization and the nature of the issue being examined. A culture assessment may include work such as developing and reviewing policies related to anti-harassment, anti-discrimination, and diversity and inclusion programs, conducting analysis from multiple angles by using interviews, focus groups, surveys, and other analytical tools, providing recommendations on how to remediate potential problems, and assisting in effectively communicating policies and programs to chief executives, general counsels, senior management, boards of directors, employees, and the media.
Prepare or update a crisis management plan. That planning helps organizations consider the types of crises that may occur, outline the processes for stabilizing and containing crisis situations, develop blueprints for required communications and methods for distributing necessary information. Identify and train key personnel in crisis response, and create and put in place processes for gathering facts, managing data, and making key decisions. Advanced plans can greatly minimize the pressure on an organization and its management as it responds to an emergency, and that helps to mitigate potential liabilities and costs. Designate outside counsel to be your outside crisis manager and work with them. It's critical to get your crisis management plan in place. That concludes our discussion today, and we hope these are helpful tips in preventing and managing a crisis at your organization. Thank you.